The record will show the presence of the defendant and all counsel. The jury is not present. Mr. Nurmi, you have a motion.
Yes, Judge. At this time, we're going to renew our motion for sequestration of the jury. Last night, there was apparently, however they were obtained, at least at this point, we're not for sure, interview tapes of Ms. Arias' parents in Wairika, California were obtained by the media, as well as journal entries from Ms. Arias' entire journal that was seized during a warrant. These were broadcast and read ad nauseum in conjunction with this motion, and in conjunction with the reports. One of the reports mentioned that the county attorney's office had provided these diaries to Ms. Arias. So consistent with this motion and also the corollary of the misconduct motions that are still pending before this court and are cumulative in nature, we would be asking that the county attorney advise the court either deny having done that or concede having done that on the record at this time.
Mr. Martinez?
I don't see the relevance of whether or not the county attorney's office provided that or not. That's an issue beyond my control, but my understanding was that there was a public record request. I don't know who made the public record request for the two videos that Mr. Nurmi is talking about. They actually don't watch the media as much as the defense counsel seems to, so I don't really know whether or not that was played or not. Additionally, there was a public record request, my understanding, for the journals, and that was something that was provided. There are many public records requests that are pending for the Maricopa County Attorney's Office right now, and I don't know what they all involve, but I do know that there are many.
Well, judges, this court knows, and the case law tells us that this case must be tried in the courtroom, not in the media. That's one of the boundaries. If we want to try this case outside the courtroom, and that's what the county attorney's office seems to be conceding now, I'm willing to do that as well. But as it relates to the jury, this is the kind of information we've just heard the county attorney's office concede that they're putting out there, that the jurors can hear. If we are to believe, you know, the court asks the question of the jurors every morning, have you seen, or not every morning, on a weekly basis, have you seen anything on the media in a group? No one raises their hand. No one wants to be singled out. But to believe that to be true is to believe in absolute fiction. It is a fairy tale to assume that this jury is not hearing any of this. It is all over the news, be it local or national. So again, you know, if this release of information done by the county attorney's office, this does affect Ms. Arias' right to a fair trial, it is disseminating information that would not otherwise come before the jury and affects her right to a fair trial. If we are to believe this fiction that the jury doesn't see any of this, okay. But again, it is a fiction that is beyond belief. I might add to this, coming in this morning, I saw the media photographer, who I believe works for HLN, move forward towards the door as he saw the jury bus. Jurors number 1, 4, 6, and 17, and I believe 13 were all coming in. I do not know if they were photographed or not. At this point, I couldn't tell based on the way the position that the gentleman was holding the camera, but we have to concede these facts as well. These are facts that the jury is not excluding. There is no doubt about it. We don't even need to rely on a fiction to know that the jurors were photographed this morning, or cameras were outside there this morning, because I witnessed it myself. So, Judge, given all this, I'm asking the court to no longer rely on this fiction that this jury is not seeing any of this media and sequester the jury immediately.
Mr. Martinez.
I'm not sure where defense counsel gets the legal authority or the clairvoyance to know what the jurors are thinking or what they're seeing. Again, it appears that defense counsel is much more preoccupied with the news and what is being broadcast than actually listening to what the jurors are saying. It's problematic to say that the jurors are lying, which is what he's saying, when he has nothing to back it up. The jurors have been on numerous occasions, I don't know how many, been asked whether or not they are subjected to any media coverage, and they have all answered uniformly that they have not. There is no reason to believe that the jurors are watching anything if they say that they are not. So I would ask that the court deny defendant's request to the jury. It's a motion for reconsideration under Rule 16. I don't see that anything has changed. The jurors have indicated that they will abide by the court's instruction, and that's what we have to rely on. We can, of course, fictionalize what we believe that they are seeing or not seeing. They have indicated that they are not seeing anything. We can question them again when they come into open court, and I believe that that takes care of the matter.
All right, the court has repeatedly admonished the jury to avoid media coverage during the trial. I have inquired on a regular basis to determine if any juror has seen or heard anything about this case in the media. I have inquired in the courtroom, and I have inquired of the jurors one-on-one in chambers with the parties present. There is no indication whatsoever that any juror has failed to follow the court's admonition or has seen even inadvertently any media coverage of this case. Based upon the law in this state, I am denying the request to sequester the jury at this time. As authority for this court's decision, I am citing State versus Shad, S-C-H-A-D, 129 Arizona 557, State versus Atwood, 171 Arizona 632, State versus Bible, 175 Arizona 574, and State versus Tyson, 129 Arizona 551. All right. With regard to the motion for mistrial that we heard testimony on last week, I understand that the additional witness is available today. Mr. Nurmi, did you want to call that witness at some point today?
Your Honor, has the court reviewed Exhibit N2?
I have not, but I will over the noon hour. I thought you wanted to present it during the...
I would like the court to review it and then have the Ms. Wong, the witness, the opportunity to review it as well.
Okay.
Right now, as a concern, given that Ms. Violet was ill and her schedule, I'm interested in moving forward with that. Certainly, if time can be made elsewhere, we can pick that motion up.
All right. Ms. LaViolette, please come forward and take the stand. Let's bring in the jury.
Please stand for the jury.
Please be seated. The record will show the presence of the jury, the defendant, and all counsel.
You forgot my glasses.
Yes. Ladies and gentlemen, while the witness is retrieving her eyeglasses, have any of you seen or heard anything about this case in the media since I last inquired? I see no hands. Has anyone attempted to speak with any of you about this case? I see no hands. Ms. Wilmot, you may continue.
Good morning, Ms. Violet.
Good morning, Ms. Wilmot.
I'd like to talk to you about some text messages from March 22nd of 2008, okay?
Sure.
I'm having you, Mr. Marshall, Exhibit 440, turn to page 63. And we're talking about the nature of their relationship and how we've talked about how it's gone from violent back to the loving respite, things like that. So when we look at the text messages from March 22nd of 2008, do you see a text message there where Mr. Alexander, in his own words, is inviting Miss Arias over?
Yes, I do.
Okay, and in his own words, is he telling her to make herself at home?
Yes, he is.
And what does that say to you about the nature of their relationship at this point in March of 2008?
Looks like a comfortable relationship where there's a lot of back and forth, and they're able to, that they're both inviting one another to things, and it's pretty, you know, during these periods, things are pretty okay.
All right. And when somebody tells somebody, in your own experience, when somebody says, make yourself at home, does that mean that they're welcome to be there?
Yes, it does.
Okay. Are you aware of any other communications between Mr. Alexander and other women where he complained of having a stalker?
Yes.
And do you know specifically the women that he said that to?
He said it specifically, I know, to a woman by the name of Reagan. He said it specifically to a woman by the name of Lisa.
And at this point in their relationship, by March of 2008, have you seen any indications of any type of stalking from Jodi to Mr. Alexander?
Lack of foundation, we may approach from
All right, Ms. Violet, and everything that you've reviewed, the text messages, the emails, the journal entries, and you've reviewed Mr. Alexander's journal entries as well, right?
Yes, I have.
And in reviewing all this information, did you ever see any type of indications of stalking activity from Miss Arias to Mr. Alexander?
No, I didn't.
At this point in their relationship, does it appear that there's any type of stalking going on?
No, it doesn't.
And do you base that on Mr. Alexander's own words when he talks about inviting her over?
Objection to reading private foundation.
What do you base that on?
On the nature of the relationship, on his willingness to have her over, on his, connection with her, as well as her connection with him.
All right. Do we have, in late March of 2008, there are a number of text messages between Mr. Alexander and Ms. Arias, is that right?
Yes.
And do you see a continuation in those text messages, and let me know if you need to review them, but do you see a continuation of this relationship of a general, natural type relationship between the two of them?
Yes. Yes.
Is there a point in time when Mr. Alexander tells Ms. Arias to empty her voicemail because he's been trying to get a hold of her for a week?
Yes, there is.
Does he ever, based on the text message, is this in a text message to her?
I get the text messages and the IMs.
Mixed up.
It's down on paper.
Okay, all right. And when he does this, is in your opinion, is he nice about it, or is more of an order from him?
He basically tells her to empty it out.
So based on what you've read of his own words, does it seem to be more of an order, or is he asking nicely? Because out of concern.
It seems like he's... Approach, please.
So based on Mr. Alexander's words in that written communication, did you consider, based on your experience in dealing with men who have controlling issues or jealousy issues, how did you take that message from him to Ms. Arias about her voicemail?
That he was upset that her voicemail was full. He hadn't been able to get in touch with her for a week through voicemail, and then he told her to empty it out. Sustained.
All right, so your impression was that he was upset about her voicemail being full.
Yes.
All right, and did you get the impression that he told her to empty it?
Yes.
Leading, hearsay.
Try to go back.
Question sustained.
All right. What was the impression then about how he told her to do it? What was your impression about how he told her to do it?
Ordering her to do it.
All right. At the end of March in 2008, did you also review a written communication between Mr. Alexander and a woman named Chriselle?
Yes.
And during this communication, is this, Chriselle was another woman that he was communicating with, is that right?
Yes, she
Okay.
was.
And in this communication, What was the overall subject matter of this communication?
It was graphically sexual.